Hey everyone, welcome to another episode of the Re-Federalist Report. I am Brady, also known as the War Hamster in some odd corners of the internet, and joining me, as per usual, my good friend, constitutional mentor, Mr. Constitution himself, Douglas V. Gibbs.
Thanks for having me. Odd corners of the internet.
Yeah. Well, we're trying to wean the War Hamster away, and we'll see how that goes. I've got so much social media under that tag; it's kind of hard to give it up altogether. But when you start talking about serious subjects, you probably want to have a more serious name than a friggin' War Hamster.
I don't know. I think it works. But anyway, it's good to have you. Maybe you need a title. It's a little more, powerful, like Mr. Constitution. I don't know. But good to see you guys. Glad you're here. For those of you who, are always looking for these specific videos, not only are they on War Hamster's channel, but I've been putting them at politicalpistachio.com as well.
Yeah, I think I've noticed a little uptick in viewership, so I appreciate you doing that. Yeah, the new year has started with some good growth on my channels. If that keeps going, we'll keep doing them.
There you go.
All right, today's topic. For those of you who've been watching for a while, we did a preview and then a review of Supreme Court decisions last year. It's called the SCOTUS Watch. We've got a new session of Supreme Court started in October, and they're doing the last few oral hearings in the next week or so, or actually this week. And we're going to give a little preview for what kind of decisions, what are the arguments pro or con for everything they're listening to. We do things a little bit differently. You can go to any, lawyer YouTube channel, and they're going to give you the legal interpretations. We're going to try to give you the constitutional interpretation of what's at stake. Supreme Court may not end up agreeing with us. They quite often don't, but that's the way. Even Thomas isn't probably go as close to the original intent as Doug and I do. But
don't get me wrong. I love Thomas. I love Alito. I love those guys. But yeah, every once in a while, a little incorporation comes in or something like that, and I scratch my head and go, "Oh man."
Well, really, just to show you that there's a semantic. I mean, there's just a difference between a textualist and an originalist. Mm-hmm. And the textualist tries to say this is what the words originally said, and what the originalist says is this is what the words originally meant. And to do that, you've got to go back and listen to what were the founding fathers in their own words saying, in their letters back and forth during the ratifying documents, all of that. And that's so you have to kind of project yourselves into that time period and say, what do these guys care about and why?
Context is everything. And the thing is, too, and this is for those of you who are new at constitutionalism, is that the founding fathers wrote everything down. We have most of the records. The only reason why we don't have all of them is because in 1814, the Library of Congress got torched. But with letters and records, meeting records, and and things like that, we have just about everything. And we don't have out of the language and out of other resources that they had at the time that would define words or let you know about the character of the people at the time and all that, and the ideas that were floating around at the time. It's not hard to determine what they originally intended.
Very good. One other oddity that I wanted to address before we jump into the cases is this is, what today's date is, January the 15th, and a new administration is sworn into, comes into office in 5 days. Mm-hmm. So this is actually the U.S. Solicitor General Elizabeth Prelogar. I think that's how she says it, Prelogar. She's arguing a couple cases this week, and it brings up an interesting case. What if the case would be pushed back to next week, and you have an all-new Attorney General and Solicitor General? Would the government still be forced to, make the same case, or And we've had examples of that in the past, when you get a transition from two totally ideologically opposed administrations making the transition from one to the other. So, I'm not sure if the Supreme Court scheduled their dockets so that it doesn't have that carryover past January 20th, but it definitely comes into play on some of the topics or some of the cases we're going through today are ones that a Trump administration or a Trump DOJ most certainly would not be taking the government positions being taken in these.
Yeah, and that's unfortunate because the law is the law. and the Constitution is the Constitution. And the fact that we have a different ideological angle, I mean, that's like saying that depending on who's in office depends on whether or not a stop sign actually means stop. You know, it really burns me the wrong way, because the law is the law, and it should not be at all. Just like, just to bring in a recent issue with Pete Hegseth in his confirmation hearing, the military should not be politically, ideologically influenced to move in certain directions. Military training is military training. Military acumen is what it is. And the law, judges are supposed to be apolitical. But we know in this day and age, especially, even back then, but especially now, that the ideological, or at least the perceived ideological power reigns supreme, and that judges will lean that way. I've even noticed it as a veteran in the VA, how the services change depending on who's president and how nice they are to you. I remember when Trump was during his first term, and they would actually say things like, "Thank you for your service." I haven't heard that at all during the Biden administration from VA. So, and it's a shame that ideology plays a part. But that's part of the reason why we want to talk about this, is we want to strip away what's ideological, so that you understand what the law says, the law of the land being the Constitution.
Very good. It just, you would hope it's not, this stuff isn't politicized, but it has been. That's just the world. That's the age we live in today. So,
right.
Vote accordingly, people. All right. First case we're going to get into is known as Garland versus Vanderstock, also known as the ghost gun case.
Mm-hmm.
High-level summary of what this is all about before we get into the arguments. Government basically has said, okay, first of all, oral arguments were already given on this on October 8th, the very beginning of this Supreme Court session. So we actually know what the pros and cons are in the arguments. We've already heard the justices' opinions. So we'll go through that. They have not given the decision, which is why this is a preview. The government's been saying that ghost guns are the weapon of choice for criminals. And if we ban them, they won't have them, which is, you and I both know, is ridiculous. Criminals don't care about the law.
Yeah, well, hey, I have an idea. Let's make drugs against the law. That should get rid of the drug problem.
Yeah, let's fight a war against it, huh?
Yeah. And real quick, if you don't mind, ghost guns. I always thought that that's a funny. It's actually very appropriate, because ghost guns, the government can't see them. They're not even sure they exist. It's the perfect term for them. And that's really what they are, is guns that have not been serialized. They've been put together either piece by piece or 3D printing, and the government doesn't know if they exist, can't see them. Ghost guns.
Exactly. There's kits you can get, and I've got an interesting little graphic here I'm going to share with you real quick.
Okay.
Let's see. We'll present that screen. So the ATF, oops, where'd it go? All right, the ATF.
Alcohol, tobacco, firearms, folks. Ask yourself, for those of you who've been around me a lot, is any of that constitutional when it comes to federal government? We'll get to that, but it sounds like a convenience store I want to shop at rather than an agency.
See, exactly. The ATF passed a rule trying to ban these, and that brings up a bunch of questions. Does the ATF have that authority? Does the ATF have the authority to exist? And that's what the case was all about.
Yeah.
What happened, if you can see this graphic, is ghost guns or ghost gun kits exploded after 2019. And that is a huge increase. And this is why there's such a sense of urgency. This is ghost gun recoveries. Now, obviously,
one is guessing probably like right around November 2019. Just saying. Man, go on.
So it's become a major issue. The ATF's been trying to crack down really hard. They created their own rule and then decided to enforce it. So that's why they've been recovering someone.
Oh, wait a second. Are you saying that the agencies are interpreting the law and then applying it as they think it means?
Yeah, I'm glad.
Yeah, wasn't there just a recent Supreme Court case that says they can't do that?
Yeah, that would be the Chevron doctrine, I believe.
As well
as
Chevron deference and yeah.
Well, I'm glad you pointed out because a number of the cases we're going to go over today are going up against that to see how consistent the Supreme Court is going to be in upholding their Chevron deference holding, and I think they're going to come through pretty strongly because there were like 6-3 and 7-2 decisions on those cases, so it was pretty popular. What are you saying in a nutshell for those who haven't watched our previous SCOTUS watch? The Chevron deference, basically, they were letting agencies serve as judge, jury, executioner. And that's no longer the case.
And interpret the meaning of the law, regardless of what Congress says it means, because you have to remember that, for lack of a better way of putting it, those who lean to the left of the Constitution, which is almost everybody, but that's beside the point, believes that everything is living and breathing. So, in other words, the law, the Constitution, or even law written doesn't mean what it says because times change, and therefore it must be looked at differently as time changes, and then interpreted differently.
And that's exactly what's going on with this new ATF rule. Basically, the Firearms Act, the term firearm under the Gun Control Act of 1968 had a pretty specific definition of what a firearm was. Now, we're not going to get into whether the Gun Control Act of 1968 was even constitutional. Well, yeah, should we?
Well, there are Republicans in the House right now that are sponsoring a bill to actually reverse that law. And there's also those who are putting forth sponsoring a bill that would get rid of the ATF. So whether or not they're able to see the light of day, we'll see. But yeah, go ahead and talk a little bit about that. And we could even go back to the other one that goes, what was it, back in the 30s, that was ultimately what got rid of your Tommy gun and things like that too.
Well, that'll come up into play with our next gun case. So
we'll
people on that. At the end of the day, long story short, for the umpteenth time, all federal gun laws are unconstitutional. Period. Full stop.
Shall not be infringed means shall not be infringed. And Second Amendment is specifically talking to the federal government.
Congress can make no law. Yeah. So that's our starting point from a constitutional standpoint.
Right.
All right, the government's argument is basically that it's a clarification to ensure that firearm parts kits are subject to the same regulation as traditional firearms. Prologer argues that they're crucial for preventing the untraceable nature of ghost guns. Well, that brings up the question, should serial numbers be on any weapon? I mean, we know what they're trying to do is to create a database of gun owners. Mm-hmm. That's always been their case. Should they be allowed to do that? It's a major question. It's not being addressed with this case, but it's...
And once a database is created and maintained and it becomes a registry, confiscation doesn't follow too far behind historically.
Yeah, the respondents to this case argued that the ATF's rule exceeded its statutory authority by redefining what Congress had not explicitly included in its definition of firearm. We just mentioned that. He also argued for a return to the previous, what's called a critical machining test, where a receiver or frame only becomes a firearm when significant machining beyond what's provided in the kit is actually needed to make it functional. The example you would give is you could ban a certain type of furniture. Would you make the argument that IKEA, would be, because they give it to you in parts? Is a piece of lead part of a ghost gun kit? Is it now illegal? Where do you draw that line?
Right.
During the hearings, you had Alito, Thomas, and Gorsuch expressing skepticism about including the parts. Roberts and Barrett were a little bit more receptive. Barrett used the analogy of a meal kit to illustrate how components can be regulated before assembly. It's an interesting analogy. And of course, Jackson, Kagan, and Sotomayor, the three musketeers, the summary I have says they're inclined to support the government's interpretation, as they usually are. There's some debate over what readily convertible means. And they also touched on the balance between agency regulatory power and statutory interpretation. And some of the justices were questioning the extent to which the agencies can redefine the terms. That goes back to Chevron deference. So that's pretty much the case in a nutshell. Do you have any? Do you want to go a little deeper into it, or?
Well, constitutionally, and for those of you who once again, are not familiar, I want to make sure we understand something about the Second Amendment and the Bill of Rights in general. The Bill of Rights was originally intended to apply only to the federal government. This is not to say that the states can stomp all over those rights that are enumerated, but it's a matter of authority and how much authority is given and how close it is to you, locality, all that jazz. But what it says is a well-regulated militia that's in good order, is being necessary to the security of a free state. So it's giving you an example as to why, basically. For example, everybody's part of the militia. Militia is necessary to keep the state free. That's how it's starting. The right of the people, that's pretty straightforward in my opinion, to keep and bear arms, to own, to possess, and to carry shall not be infringed. And so what that means is, if this applies to federal government, shall not be infringed means in any way. Therefore, every single federal gun law is unconstitutional. So first of all, it doesn't matter if it's serialized or not, whether or not it was completely put together before the sale or afterwards. None of that matters from just the basic boilerplate constitutional angle. All federal gun laws are unconstitutional. So the ATF not only has no authority to make this decision, they don't even have the authority to exist. Now, that said, because tobacco and firearms are also not, tobacco and alcohol is also not listed in the Constitution as authorities of the federal government. In fact, they know about alcohol because last time they tried to ban the stuff, they had to do an amendment. Now it gets deeper. So now we ask, well, are they allowed to interpret the law? Now, we have to remember the ATF is not a legislative body. It is a part of the executive branch to execute law. Well, when you execute law, that means you're going to execute it as it's worded. So do they have any legislative powers? A legislative power would be the ability to change its meaning or to say that it means something else. The Congress wrote the law. Congress defines it. Congress decides what they meant, not the ATF. And they can, and no other branch can do that. How do I know? Because in Article 1, Section 1 of the Constitution, it says that, I'll read it word for word. Normally I have it by heart, but right now my brain is on something I'm going to say and not thinking about it. All legislative powers herein granted shall be vested in a Congress. So legislative powers, that's the power to make law, create law, modify law. So what are they trying to do here? Modify the law or repeal law is vested in the Congress. The word vested, if you go back to the original meaning, what they meant when they wrote this, when they put it in the Constitution, doesn't just mean that it's granted to Congress, but that it is exclusionary and irrevocable. In other words, only Congress has that authority. That's called separation of powers, my friends.
And it's important not just from a right to self-defense standpoint or Second Amendment standpoint. This goes across just about every aspect of your lives that is overregulated.
Right. If they're getting away with interpreting the law to mean what they want as an agency here, then that means they do it in any agency.
Yeah, and that's what was overturned with the Chevron deference for the most part. Mm-hmm. And that's being put to the test. So what's interesting is the name of the case is Garland versus Vanderstock, meaning the U.S. Department of Justice was bringing this case. Had it not gone to the Supreme Court this session, a Trump DOJ would not have brought this case. The other important thing I think to realize is the people that were pushing this, that led the whole fight for this, was Everytown USA, which is the nonprofit group or NGO that wants to ban all guns. So that's where they're coming from. A couple other interesting things. Okay, so the Fifth Circuit has already overturned it.
So real quick, if anybody's wondering, Garland, Merrick Garland.
Yeah, that would be the
Just in case anybody isn't, just
five more days of him. So no lower courts have had a contrary ruling. So it's going to be the Supreme Court has actually got to overturn and that's not always that easy. But the Supreme Court did grant relief twice to the ATF while the appeals process is going on. So whereas the lower courts have ruled that this ghost gun ban cannot take place, the Supreme Court has put that on hold pending this case. So they will be the final arbiter of this. I am not sure which direction it goes. if they're consistent with both the gun rulings and the Chevron deference from last year, they've got a couple of outs, and they,
and you do have Thomas and Alito at least being pretty persuasive in past cases regarding gun rights, and there's been a number of gun rights cases that have made it to the Supreme Court, and whether the findings were constitutional or not, they were in favor of the right of the people to keep and bear arms. And so I'm going to, and Thomas and Alito being, aside from Roberts, your senior justices, and I know you don't think that the left really gives a toot about any of that stuff. I think that their status, the stature of their position, does mean something, and I do think that their arguments are listened to more intently than, say, arguments from Kavanaugh or Barrett or something like that. And so I think they'll be, and also remember who's coming into the new presidential administration, and I think that will have influence. And so I think they will go in the right direction on this and say that ghost guns cannot be regulated, and that the ATF decisions they overstepped their constitutional authority. Of course, their existing oversteps constitutional authority. That's beside the point. But I do think the court's going to, for the most part, get this one right.
Yeah, it'll be an interesting one. And once again, once the Supreme Court does their little 2 weeks of dumping all their decisions on us, Doug and I will be probably having like 4 shows of a 2-week period. And we'll go into a much deeper dive of once we hear the Supreme Court arguments and dissents. Because that's
what we'll do is we'll go through the judicial opinion and break it down for you. Were they right? Were they wrong? Why did they use that opinion? What did they mean by it? Things like that.
Okay, before we move on to the next one, there's one question we should always be asking about all these cases is, and does the Supreme Court even have the jurisdiction to be ruling on it?
Right.
Is this, or should this be an issue left to the states? In this particular case, it is a national issue with a federal agency, the ATF. I'd make the argument that the Supreme Court should almost absolutely had to have been the court of, they definitely have jurisdiction. Would they have, they don't have original jurisdiction for a number of reasons, so it was brought in lower courts.
Well, and that's the reason why it's the reason why they did it the way they did, Garland versus Vanderstock, rather than the United States versus the ATF or something like that. Because if the United States is a party to the case, then it's going to be pushed upward.
Yeah,
that's why they do these names.
Yeah, and they actually have a choice of how they're going to bring the case. And something to keep in mind is the Supreme Court does not like to be the first court that hears on a case. They'd like the fact-finding and the arguments to be laid out on the lower courts before they go. It's sort of like you got to go through the minor leagues before you get to the big leagues because you find out, what the player's all about. Decent analogy? Yeah,
decent analogy.
I'm sticking with it. All right, the next interesting case, also sticking with the gun laws. There's a case called Maryland shall issue versus Moore. Now, this is denied a petition for writ of certiorari. Thank you. Such a tough word. It was denied on January the 13th, so 2 days ago. This one, Supreme Court chose not to hear this one. And there's some interesting comments that were made about that. What's this case about? It's which gun rights groups and gun owners challenge Maryland's requirement that most residents obtain a license before buying a gun. Court of Appeals, Fourth Circuit, pointed to Thomas's opinion in the Bruin case, in which he indicated that laws that required gun owners to undergo background checks or complete gun safety courses will generally be constitutional under that decision's new Second Amendment test. That's the Bruin case, which is it's the big landmark gun rights case that kind of superseded Heller and the previous ones.
And this is huge because what it does is it brings into focus all of the states that have shall issue requirements. In other words, you're not going to get your your ability to carry or your license or whatever until this happens. In California, it's you have to show the need to carry a gun. Well, I deliver diamonds, so I might get robbed. Okay, so that's a shall issue. And so that's what's really on the table here is the shall issue question. Now, the arguments in the past on these cases, so there's a lot of precedent when it comes to these types of cases with the shall issue cases. And the precedent basically says that, and once again, they use the Second Amendment, and the Second Amendment applies federally, but let's go with it. Basically, there's nothing in the Second Amendment or in any, because remember, historical context has become a big deal with the courts. What is the past showing us? And there is nothing in the past that says that a right must have anything that allows it to happen. A right is a right. If there are things that must be accomplished in order to obtain your right, if there are things that can happen that can make you lose your right, it's not a right. It becomes a privilege and becomes the right versus privilege question. And that fine line is really what's at question here. If you have a right to keep and bear arms, if you have a right to carry, then there should not be any requirements any hoops you must jump through in order to carry out or practice to enjoy that right. That's what's at stake here with Maryland shall issue versus Moore.
Yeah, there's two other things that need to be addressed upon it. Their argument is that because the state law, keyword state law, already requires a background check for firearms, then a license requirement, which also requires a background check, does not impose too heavy of a burden. The big issue to me is these are state gun laws, and it's being settled in a federal court. This is a point we keep hammering home over and over again. But why does a federal court have any jurisdiction over a state issue?
Well, I think part of the reason, and by the way, the justices did deny that the Supreme Court is stepping into this as of 2 days ago. Yep. But there's, and that's because once again, there's precedent. Oregon actually had a similar law, and its state courts struck it down. And so, I think they're using that kind of also saying, hey, let the state take care of it. It's up to the state constitution. So I think the reason why the justices denied review is not only because they don't want to take it, but I think, I think they should have said this, it really belongs to the state courts.
I agree with that's the last part of it, but this was heard by a federal court of appeals before they got to SCOTUS. So no, they're not thinking in terms of incorporation yet, that's the win we all want to get to. So every single one of these cases, if they give us an inkling that the Supreme Court is going that direction, it's a reason to celebrate.
Yeah.
All right, they did take the case in what is known as Snope versus Brown. And what's Snope versus Brown? It's a big it's a case challenging Maryland's ban on assault weapons. Assault weapons is with giant air quotes because they can't even define what that is. The petitioners, which is Snope, argues that assault weapons, air quotes, banned by Maryland are in common use for lawful purposes such as self-defense, sports shooting, etc. They cite the Supreme Court's decision in Heller, which states that arms in common use for lawful purposes cannot be banned. Okay, that's reasonable. They go into the historical analogs that were created by Bruin, talking about Maryland can't provide any historical evidence to have an assault weapon ban. They never had it.
Remember what I said earlier about history and exactly. And
then Maryland respond. Well, do you want to get into that? No, I'll pass on that one. Well, yeah, they did mention it. They said there's an argument for the consistency in the Second Amendment jurisprudence across judicial circuits, emphasizing that rights should not vary significantly based on a geographical location. There's a problem with that argument because each state has the right to make its own gun law, so they most certainly should vary based on geographical location. The respondents represented by Maryland's Attorney General, a guy by the name of Brown. He says it makes the public safety regulation. We'll save lives because criminals listen to our laws. They use a criterion that Maryland contends that the banned firearms are, again, air quotes, dangerous and unusual, which is a criteria straight out of Heller.
All right. Well, and remember, this is a ban on what they call assault rifles or assault weapons. And while that terminology does not include these weapons, they're talking about AR-15s, AK-47s, things like that. And one of the things that strikes me about this case is the implications if the court takes it and then the court says the state cannot, say that this firearm is different from that firearm, so the assault weapon, label doesn't matter. It's still, a violation of the right to keep and bear arms. Then at what point does someone bring a case to broaden that and maybe even go back to, your automatic, for example?
Yeah, where do you draw the line? It's either no law. Yeah, it's important, and it can't just keep dancing around the margins.
Right.
One of the other arguments Maryland is making is that these weapons are due to their design for military use, fall outside of the Second Amendment's protections.
Yeah, the AR-15, I'm going to tell you right now, folks, not only because I spent time in the military, but also because of my military compadres that I hang out with. The AR-15 that you can buy and the AR-15 used by the military are not exactly the same. While the AR-15 does have punch, more punch than maybe your hunting rifle, it's basically a glorified hunting rifle that looks scary and has a little bit more punch. But the AR-15 used by military personnel, there are certain aspects to them that are slightly different. Now, that said, from now a purely constitutional point of view, who cares? What's the point of the Second Amendment? The point of the Second Amendment is to defend ourselves against a government in case it goes tyrannical. So then, if that is the case, should our ability to access weapons be those of equal to or greater than that of the government? Because that's who we're going to have to fight if the Second Amendment goes into its original intent.
One of the other arguments we're expecting to hear is what's called a legislative prerogative. And you're gonna love this. Basically, they're saying Maryland could argue that the legislature is the best position to decide what constitutes a threat to public safety, and that the courts should defer to these judgments unless they're clearly unconstitutional. They're making a states' rights argument that this is none of the federal government's business. I'm okay with that argument. I happen to agree. And people get mad at me sometimes, so it needs explanation. When we say states can make their own gun laws, well, they can because of Article 10 of the Constitution. They weren't banned from doing it. Therefore,
not Article 10, Amendment 10.
Sorry, 10, thank you. Mr. Constitution correcting me on the Constitution. Imagine that. But, and it's what we always say, I believe in the right to self-defense, and I don't want any gun laws to prevent my ability to, protect ourselves and to defend against tyrannical government. But your first line of defense against tyrannical government is not the gun you have in your safe or on your hip. It's your state. And your state controls the militias. If you are in a state that does not allow you to arm yourself, you got two choices. Work to fix your state gun laws or get the hell out. And that really is the choice. It's much better than basically going running to the Supreme Court and saying Second Amendment, because if you give the court power to say what is a legal gun law and what isn't, what happens when you get a liberal Supreme Court? They still have that power, and they can take away all of your gun rights. So it's important that these powers remain with the states.
And when it comes to legislative prerogative, it goes back to what I was saying earlier about Article 1, Section 1. All legislative powers herein granted shall be vested in the United States Congress of the United States. Legislative prerogative is rooted in the idea of a separation of powers. It is all about making sure that the legislature and the executive and the judicial operate independently of each other. And the judicial branch is not supposed to be the final arbiter of what a legislature can do. The final arbiter of what the legislature can do is supposed to be those who place those representatives there. In the case of a state legislature today, that would be the vote of the people. So the final arbiter would be the people. And if the people say, wait a second, that's wrong, then it is up to the people either to bring the case, which of course now they say we don't have standing, that's beside the point, or to remove the persons that are making law that offend the constitutionality. Now, the difficulty there is that requires an informed public that's willing to be involved.
Yeah, that last caveat's a big deal, and that's where we've dropped the ball. It really is. So this was making its way up the courts. There were some dissenting views that went against the majority, but I'm going to read the summary of it because it says a couple of really important things. In lower court decisions, dissenting opinions have criticized the majority for not adhering strictly to the Bruin test, emphasizing, here it comes, that the Second Amendment's core purpose is to protect citizens against tyranny, which includes the right to possess firearms effective for that purpose.
I love that wording.
Yeah, they're making two different points here. They're making three, actually. But first is they're saying the Second Amendment applies to everybody, which basically assumes incorporation. We're not going to go deep into incorporation today, but we disagree with the concept. It's not original intent. It means the Bill of Rights does not apply to the states. Second thing they got right was it protects citizens against tyranny, and once again, which includes the right to possess firearms effective for that purpose.
Which goes back to what I said earlier. Remember, we should be able to access firearms that are equal to or greater than those of those of the aggressors.
Yeah, that's an important historical point, and Carol Quigley talks about this in Tragedy and Hope. He makes a historical point that throughout history, the periods of time where the state or the government has a technological advantage in weaponry, we have tyranny. When the citizenry are at roughly equal ground, you get freedom. And you just look back to 1776 for the best example of that. Our muskets were just as good as the Brits. And there's examples of that throughout history. So that's why that's such an important point.
If anything, ours were better.
To some degree, those homemade muskets were pretty good. This is a big deal because this is going to set a precedent for how quote unquote, assault weapon bans are viewed for laws in other states. And that a lot of these states, there's cases that are going to be challenged. There are a number of blue states that have tried to ban, once again, assault weapons.
Yeah, for those of you who are curious about that term, from a military standpoint, an assault weapon is one that can be freely changed from single shot to semi-automatic to automatic with ease, with basically a lever or something like that. That is really the military term of what an assault weapon would be. And and anything that has automatic capabilities are not allowable anyway by law. Secondly, the word assault, if you really want to get down to the nitty gritty, means to be able to come against somebody. Well, then if I hit you, I have an assault fist.
Yeah, and we should ban assault SUVs like in New Orleans.
Exactly. So using that way of looking at the terminology, well, then every firearm is an assault weapon, and that's the point. That's why they use that term, because they keep broadening and broadening and broadening the definition until eventually it will be all of them, because that's creeping incrementalism. That's how they operate, and that's the reason why we got to stop it right now.
So it'll be an interesting case. I think this is going to go the right direction, but possibly not for the right reasons. If we were going from a purely original intent standpoint, what the Supreme Court should have said is, this is none of our business. Maryland gets to make their own state laws. Let them take it up with Maryland courts. Maryland being a deep blue state, they would be able to ban assault weapons. And I feel sorry for the people of Maryland. From an original intent standpoint, you get what you voted for.
Well, and it gets nasty enough. Guess what? The same thing that would happen in Maryland, which I think is starting to happen in California when it comes to the wildfires. People are going to start second guessing the leadership they chose.
Yeah. And a lot of these things probably require a change of a state constitution, and that's where I would challenge it. I would challenge it on the state level of the Maryland state constitution. All right, let's see. Which one do we want to go to next? How about, here's a big one everyone's talking about. Free Speech Coalition versus Paxton is being argued today. And this has to do with having age limits for being being able to view pornography. So give me 1 second, and I'm going to pull up some notes on that. Do you ever watch this stuff when they're doing the arguments in court?
Sometimes.
You can go onto YouTube. Do I have the right one here? Okay, there we go. You can go onto YouTube and listen to it. They don't show the pictures. They don't let the cameras in the courts, but it's pretty entertaining watch if you have the free time and no distractions. Listening to the questions from the justices, and you can really get a feel for what direction they're going here. This right here is a free speech coalition. They're challenging Texas Bill 1181, which basically mandates age verification for accessing websites with content which can be deemed harmful to minors. Interesting thing going on in this case. I'll get to that later. We'll do that one later.
Well, one of the arguments has been that you require age verification for a rated R movie. You require age verification for other things that might be harmful to a child. Why is this any different? And even when it comes to purchasing things online, there are certain things where it requires an age verification, or the minor cannot pick it up at the post office and would need to has to be signed for by someone of a certain age. That's really what's in the question here. I believe the question goes deeper than that, and that is, and once again, we're getting back to incorporation. Does the First Amendment, free speech, apply to the states, or can the states make laws regarding this? Now, you also got to look at the Texas state constitution. What does it say about free speech? What does it say about the government's ability to impose standards on certain entities regarding the publishing of materials? And so there's really the question. In this case, I don't believe this is an issue that should have gone to the federal courts. This is something that's totally up to the state. And it should have the case should have arisen and died in the state courts.
Yeah, I would agree with that. There is some interesting.
The reason why, by the way, they're saying it's a federal court is because the internet crosses state lines.
Yes, and that's why federal courts. And you're talking about if I have a website in New York, do I have to have 50 different rules for 50 different states? That's completely impractical.
Well, now, before you say that's impractical, remember, companies who operate online do have to abide by the sales tax laws of each state. They have to charge a sales tax based on which state they're selling in. So the argument would be, well, hey, if you could do that with sales tax, why can't you do that with something like this, where some states have age verification, some don't? We have a technology for it. That, I think, would be one of the arguments.
No, that's a really good point. And that's if you apply that same standard to international laws, we see the same thing. And that's going to come up a lot because you're seeing the European Union crack down really hard on the censorship programs of the American big tech companies. And that's a fight that's going to take place during the Trump administration. You notice how all the big tech bros are getting all buddy-buddy with Trump?
Oh, yeah. Well, and I have surmised that part of that is because Trump believes that AI should be allowed to freely develop without any governmental interference, and that's the next big boom.
Yeah, I'm a big fan of some of the AI tools. I understand the danger and stuff like that. One of my tech, I'm not going to get into too deep, but
every tool has its dangers.
Sure.
But if any of these things start calling themselves Skynet, though, just get nervous.
One of my tech guys says that's not going to happen. Computers will never become sentient. Yeah, you can program.
I don't think so either. But they can be used for nefarious purposes, but so can anything else. Nefarious people, not tools, are the problem.
Well, they're being used for nefarious purposes right now. You see all the brainwashing that goes on.
Sure.
Gaslighting, what have you. So the issue,
which could tie us into another case we may talk about, the TikTok case. But anyway, go ahead.
We're going to get to TikTok for sure, because that's a big one. Issues at stake, of course. They're arguing it's a First Amendment violation. This goes back to who was it that said it? The Supreme Court justice. I can't define pornography, but I know it when I see it.
Yeah, that's a great quote.
Uh-huh. Who was that again? I'm trying to remember.
I can't off the top of my head, and it's a well-known.
Yeah,
I want to say it was someone like Gomert. It wasn't, but it was someone like that.
It was like late 1970s, early 80s.
Yeah.
That court. They're talking about invasion of privacy concerns, protecting your ID, all that sort of thing. That's a hogwash. You have to show ID to do a lot of things. The question is, do they,
Well, and the thing is, a lot of people want the internet to remain kind of the Wild West, and I think in many ways that's important. We want, as little regulatory control over the internet as possible. But at the same time, it was Christian parents, for example, that pushed for the rating system for movies, and that's where the rated R thing comes from. Because we do want to protect our children. So we've got to kind of weigh this societal, cultural health versus what the law says and was intended. And you got to, figure out where the two meet. And that's where this is a difficult case.
Yeah, the framers of the Constitution weren't too worried about collective morality. These were Puritans for the most part.
True enough.
But they also wanted to avoid anarchy. And there's a difference between the two. The real big issue here, and this gets a little bit wonky with court, is really the standard of review. And there's some cases with precedent. They're going to quote, if you want to listen to the arguments, they'll be quoting a case called Ginsburg versus New York and another one called Ashcroft versus ACLU. And they set a standard of review. Is it there's something called strict scrutiny versus rational basis. And we're not going to go too deep into that, but that's really what they're going to be deciding. Standard of review is a big deal. Is this going to impact online privacy and free speech? And could it potentially give broader applications to other things? So it's an important case, and I have no idea which direction this Supreme Court is going to go on this one.
Well, and ultimately, when it comes to strict scrutiny versus rational basis, it's really going to come down to and I don't like this terminology. I'm using the way that the legal system looks at it. Are these fundamental rights, and do these policies directly affect fundamental rights, or is it a legitimate interest of the person or the government? They start kind of trying to weigh all of that, and it really gets into the I hate saying it this way, but the legal mumbo jumbo of the world. And because you got to remember, lawyers are not in play. They do not operate for the purpose of protecting the law or following the law, but twisting or manipulating the law for the sake of their clients. And so we start getting into, okay, well, is there a compelling government interest here, or a legitimate governmental interest? Is this idea by government reasonable and not arbitrary, or the opposite? Or is the law itself, the way it's written, narrowly tailored to achieve whatever interest is expected to achieve? Is this the least restrictive means to achieve the interest? Once again, you want to make that balance where government is operating within legal bounds, but doesn't become too restrictive, overstep its bounds. So this is what we're looking at here. So the question is, what type of scrutiny does this law require when it comes to the courts?
Yeah, and if I get a chance to nerd out this weekend, I'll listen to a couple hours of the oral arguments, because I think it's going to be really fascinating to hear which justices ask which questions. But again, I don't know which direction they're going on this one. I don't have any kind of a feel for it. Okay, here's another big one. The transgender surgery for minors. It's called United States versus Skrmetti. That was heard oral arguments on December the 4th. Interesting part here is one of the lawyers arguing for the ACLU, American Civil Liberties Union, is a guy by the name of Chase Strangio. And he's famous for being the first transgender lawyer to ever argue in front of the Supreme Court. So we have a transgender lawyer arguing for transgender surgery for minors. Okay. You understand why this is a controversial issue. This comes around a Tennessee bill, Tennessee Senate bill, which prohibits healthcare providers from giving this quote-unquote gender-affirming care, including hormone therapy and puberty blockers to minors. We all know these issues. They've been on the front pages for a long time.
And remember, and despite the arguments to the contrary by a certain particular ideology out there, a lot of this is part of the reason why this is such a big issue is not just because it's being done to minors, but because these actions are being initiated typically without the parents' consent.
So the case is known as United States versus Skrmetti, brought to you by the ACLU's on up. So you have the full power of the United States government arguing against the state law to allow them to butcher kids anytime they want. And it makes some interesting arguments. They talk about the equal protection challenge. Does the Tennessee law discriminate based on sex? No, it's discriminating based on age. But the other arguments they talk about is medical necessity. Like they're saying that gender affirming care saves your life, although there are no studies that back that up, no legitimate ones. And everything that's coming out of Europe, and this is a big deal, it's going to be brought up in this case. One of the Supreme Court lawyers, I want to say it was Gorsuch, quoted, says a fair amount of discussion about recent transgender treatment developments in Sweden, Finland, and the United Kingdom. For those who aren't paying attention, there's been a ton of studies coming out of Europe that show this gender affirming care stuff has done a heck of a lot more harm than good. The early studies that justified this were completely unfounded, and these transgender surgeries are being banned everywhere they've done these studies in Europe. The Supreme Court is going to weigh the new scientific evidence. They quoted it in the arguments. So this medical necessity stuff, that decision is never going to fly.
Now, when it comes to this case, the oral arguments have already been heard.
Yeah,
back in December. So we're just waiting for the decision. But it really comes down to, according to the plaintiffs, on whether or not due process, your right to due process, the child's right to due process, and the parents' right to due process and equal protection, which comes from the 14th Amendment, are being applied. That's what it's coming down to, is those two things right there. That's why this is so important for us to talk about. In your due process, the same due process and equal protection argument is also being used when it comes to abortion. When it comes to the child themselves, is that child has a right to life? How are they being given before death? Because you have a right to life. And 14th Amendment and the Fifth Amendment both says. Fifth Amendment and 14th Amendment both say the same thing, that you have a right. I want to find it here. No person shall be deprived of their life, liberty, or property without due process of law. So here's the question: Is the due process of the law required before decisions can be made for these children who are not only incapable of defending themselves through due process, but then it becomes the parents? Do not the parents have the right to make sure that there is their due process, which includes acknowledgement, knowing, and then equal protection? Everybody needs to be treated equally under the law, but children are being treated unequally here. If in the case of when they were adult, you could not do this without their consent, and they're not able to make consent under the age of 18, then that means that this is being done without the consent of the parents, and therefore equal protection is not being applied. So, that's really what it's coming down to. And I really do think that the Supreme Court is going to lean in the right direction on this. I really do. Not because of the moral question, although I think that's important too, but because of the due process and equal protection question, because the left-wing justices know that if they don't defend equal protection here, equal protection starts to unravel elsewhere. And equal protection is a foundational argument for a lot of your civil rights arguments.
To me, the hypocrisy of the state's argument is not the state. The government's argument on this is really bad. They make the assertion that the law infringes on a parent's rights to make healthcare decisions for their children, and yet we've heard them arguing the exact opposite when it comes to don't ask, don't tell in schools. If someone claims to be transgender or changes their name or their identity, teachers are not allowed to tell the parents then. So you can't have your cake and eat it too. To pick one side or the other of the argument, because the Biden administration is making both sides of that argument, and you can't do that. We need consistency.
Well, and if they're going to play this game, then once again, then where does the line get drawn? I mean, as the joke goes, they can the child can have their genitals mutilated without parental consent, but they can't get a tattoo or smoke a cigarette.
Well, we know exactly where the line's drawn, and it has been crystal clear for a long time. It's called the day you turn 18 or become an emancipated minor. Mm-hmm. Then you can make your own decisions. That has been that we've decided that a long time ago, and it's across the board. There are ages of consent,
right? And so that once again, that's one of the reasons why I believe that this will head in the right direction, and especially because parental rights have been at the forefront when it comes to what's going on in our country, and the government's gotten a punch in the nose a few times over this stuff. Going as far as to call the parents who are at their PTA meetings or at city council meetings concerned, or school board meetings, calling them domestic terrorists because they're concerned about their children. And the government received a punch in the nose, specifically the Merrick Garland DOJ received a punch in the nose because of that attitude. And so I think I really do think when it comes to Supreme Court, what happens culturally when it comes to things like that also influences their decisions, and I think we're going to see this one head in the right direction. But we'll see. Well, no, and once again, they've already heard the arguments. We're just waiting for the decision.
Yeah, and from the arguments, I've got a summary here. It talks about the conservative justices. They seemed inclined to uphold the law, and the logic here is pretty good. They're focused on the state's legislative authority to regulate healthcare for minors, and they question the extent to which judicial review should interfere with such legislation. If that's
and that's a win. That is a big win right there.
It really is. That language is important. They question the extent to which judicial review should interfere with such legislation. Apply that to all these other issues, whether it be gun laws, abortion, and stuff like that. The conservative justices are making the states' rights original intent argument here. So this is a big case.
Well, it's not just that, but they're also making the argument that because judicial review is basically the court's ability to determine the validity of a law based on constitutional means or other means. And that is really a legislative power. And so the question is, so what they're really saying is, how far is the court allowed to go into the legislative world?
Yeah, and they're making the argument the way I think we would want them to. Mm-hmm. Interestingly enough, one justice didn't say a word during the entire hearing. Justice Gorsuch never asked a single question. We have a pretty good idea. Well, his vote might be the swing vote. So it should be very interesting to see which way he breaks on that, because he's given no indication one way, unless you look at his track record, and he's erred on the side of states' rights over the last several years. All right, let's jump into TikTok. The TikTok and ByteDance versus Garland. It was argued last Friday, January 10th. And of course, obviously, this one has been in the news quite a bit. Bear with me, I got to find the notes again. You ever use TikTok, Doug?
Yes. I have a TikTok account, but I view them. I've never posted.
I have never been on TikTok. I've seen some TikToks.
I enjoy it. Especially once it understands you in the beginning. I kept getting dancing girls with very big breasts, but then once it realized that was not my interest. I mean, I'm not going to get deep into that, but my interest is more political, and so then once it learned that that's what I was, putting a thumbs up to and stuff like that, then I started getting more conservative-minded, type videos, and so I really enjoy it. And the problem is it's very It's very addictive. You'll sit there, you can easily sit there for hours just going through video after video after video. But I do use it every once in a while. Sometimes I'll get a chance to watch them, and sometimes I learn some stuff, because some of these TikTok producers, individuals out there are, they're talented and right on with what they're trying to put out there. And I also sometimes learn what the other side has to say too.
Yeah, it's interesting. It might actually be a really good platform for you to put up 5-minute, 10-minute shorts and gain it.
Well, I was going to do I've been wanting to do 1 to 2 minute shorts actually on there. I just haven't gotten around doing it yet. But I think TikTok is a valuable tool. It can be a valuable tool. And this is what I was saying earlier about tools. The tool is not the evil thing. It's the user. If it's going to be used for nefarious reasons, it's not because of the tool, it's because of the person. Now, that said, the question in this case is the person or persons behind this whole platform is Communist China. So the question is, should Communist China have a say in the information that comes across the internet into the little minds of our younger citizens? That's what it's ultimately coming down to. So it's not the tool that's being argued, it's who's behind it.
Yeah, and it's the algorithm. Is there a different algorithm for TikTok in China than there is here? Well, with TikTok, first of all, TikTok's ownership structure is very complex. Yeah, their ByteDance, the parent company, is based out of Beijing. TikTok is a U.S. company, and TikTok will make the argument that we're separate off, we're walled off, we do our own algorithm. And I don't have the technical chops to argue that one way or the other. The issue really comes down, and one of the major issues comes down to data security. Do we want a foreign adversary getting that much access to that many American citizens? And the answer, of course, is no. Where it gets interesting is obviously the name of this case is TikTok and ByteDance versus Merrick Garland, meaning they're suing the United States government over a law that Congress passed. The Trump administration probably is going to take a little bit different tactic. And, after once arguing to ban TikTok, Trump kind of pivoted when he listened to Barron Trump, and he started doing TikTok videos, and he gained millions of followers, and it kind of helped him in the election.
Mm-hmm. Yeah, Barron Trump, whenever he turns 35 for president. But anyway.
The Trump team filed an amicus brief in this, and right. It's pretty bad, what they said. And I'll give you a quote from it. They want Supreme Court to defer judgment on this until Trump gets into office. That's what they're saying, because Trump alone possesses the consummate deal-making expertise, electoral mandate, and political will to negotiate a resolution to save the platform while addressing national security concerns.
Well, and here's the thing. Let me insert this real quick, and some of you might not like me about this. This is saying, at what point are they allowed to violate your rights? And because this is a free speech question here, because they tell you, and this is where this is, and you're going to love this. Well, yeah, but this is an emergency. It's national security, and emergencies trump. No pun. No use of that word intended. Otherwise, trumps your constitutional rights or your natural rights. And this is a national emergency. This is a national security issue. Therefore, your rights can be violated for this purpose. And so, so, do we want emergency use authorizations, for example, to trump your righs? And so this is where the question really lies, and that's why it's such a delicate case. Yeah, and it's going to have broad implications. During the hearings, the justices' questions were interesting. They stayed away from the First Amendment, and they were focusing more on the national security implications. And remember, TikTok ByteDance is arguing totally that it violates First Amendment. That's their argument, and that's what the court's dancing away from. So that is interesting. And what Congress focused in their law. This has nothing to do with First Amendment. It's all about national security, and that's the reason why the courts are taking that position.
Well, I'm fine with Congress focusing on national security, but that's not what the courts are supposed to do. They're not supposed to be political, and foreign policy and foreign national security is political. The courts should not arguably be involved, and that shouldn't be their consideration.
Well, and there is a idea that goes with that's called political question, and I'm very familiar with political question because one of the reasons why the case that I'm involved in with Kamala Harris, political question came in play, and basically we were told you can't pit the courts against the legislature. Is that not what this is doing?
Oh, very much so. Every time they exercise judicial review, they're doing that, Doug. Mm-hmm. If you want to go that far. This is going to impact how our government regulates just about every foreign-owned tech company. And they can't just go out and spin off, I got a U.S. subsidiary, so, we're good to go. You still.
And how broad does the definition of the enmity of another country become so that they can play the mercantilist game and pick the winners and losers and pick who's going to get government favor and who isn't? I mean, I really think it's a dangerous mercantilistic path. Once again, I understand the dangers of communist China. I am not downplaying that at all. But we got to be careful that we don't get into this mercantilism game where we got the government picking the winners and losers. Now I do get the trade aspect of this too, though. Government has the right to determine who they trade with, and you could, in a sense, say this is international trade. And so, once again, you can go either way. Does government have the authority to dictate who we trade with? Yes. Does the government have the authority to dictate freedom of speech? No. And this case comprises both of those things.
Very good. I expect them probably to rule. I don't know. A lot of their questions had to do with, is it feasible to even break up TikTok? And the answer probably is yes, from a corporate standpoint. There's plenty of buyers lined up. I hope it's not Elon Musk because, again, we want to avoid concentration of power and wealth, and he's got quite a bit of influence already.
And I believe they're going to rule in the direction that I was just talking about, that the United States has the authority to determine who the United States trades with. And I think that is the aspect. I think national security is important. I think freedom of speech is important. But I think, and I don't know if they made this argument because I have not heard or paid attention to the oral arguments here. I'm going off of just my gut feeling. I think if justice is going to say one way or the other, it's going to be that as a body, Congress has the authority to make law regarding when it comes to foreign entities, who the United States trades with, who is allowed to bring their products into the United States, and who we can send our products to. The Congress can say, no, we're not going to receive products from such and such country. We're not going to trade with that country. Congress can do that. And I think that's going to be the deciding factor here.
Just wanted to throw out a juxtaposition or a comparison.
Go ahead.
One of the things going on in Brazil is their Supreme Court is basically saying, oh, Twitter, you're being banned because we don't like your politics, because you're allowing free speech on your platform. So that's a foreign government deciding they're not going to trade, with a certain company. This is why this is a slippery slope. This can get very dangerous when you start doing political censorship. So we want to err on the side of caution of that because, again, any power you give a government, it will eventually be misused.
Right. Well, and I didn't say by them leaning towards a trade that's a good thing. That's what I think they're going to do. And any time that you have government dictating whether or not a business can operate in a certain way or be owned by a certain individual, that's always a dangerous ground to tread on. Absolutely. But once again, I believe they're going to side with we can determine who we trade with.
And I think what Donald Trump's pushing for is saying, look, the law is imperfect. It's full of holes. Let me see if I can negotiate a better deal that addresses everybody's concerns. That's really what they're trying to do.
And you know what? Don't ever downplay his ability to negotiate. It's like when somebody asked me about something like Greenland as well. Denmark said they're not going to. They haven't talked to Trump yet. The man. Not that I want to make this a Trump show here, but the man is extraordinary when it comes to his negotiation skills. And truly, I've watched people who hate him sit down with him and they come out of the room a fan. to know him truly is to love him in those types of cases. The man knows how to negotiate. He knows how to convince. He knows how to encourage. He's got that charm. He's got that ability. He knows how to whatever. I've not been in the room with him, so I don't know what that magical spark is, but whatever it is, he's good at it.
I'll give you that. Okay, let's see if I've got we got time to do 3 more cases, I think. We'll go through these a little bit more quickly. First one I want to do is another couple of cases. It's called Sunoco versus Honolulu and Shell versus Honolulu. And this is, sure, this did get certiorari, and I'm not sure what date it's going to be held, but maybe I do have that here. Hang on. Okay, so this was denied a writ for certiorari, again, 2 days ago, and it's important. I'll just read from this, from SCOTUS blog. A pair of cases seeking to hold oil and gas companies responsible for their role in increased fossil fuel consumption and greenhouse gas emissions, which led to climate change-related property damage in Honolulu. So it's Hawaii going after the oil companies. Supreme Court.
In the name of climate change.
Of course.
Yeah, and the Hawaii Supreme Court cleared the case to go to trial way back in October of 2023. But the oil companies appealed to the U.S. Supreme Court, hoping to have the case dismissed. And the Supreme Court here has just said, nothing to do with it. So that means the lawsuit's going to proceed back at the local level.
And that's pretty similar to what happened here, but the people making this argument are interesting. So reading further, in June, the justices asked the Biden administration to weigh in on whether federal law bars the oil and gas companies' state law claims. In a brief filed in December, U.S. Solicitor General Elizabeth Prelogar urged the justices to deny the review. Okay, here's where it gets interesting. She told the justices that, among other things, at this time, the Supreme Court lacks the power to review Hawaii Supreme Court's decision allowing the lawsuit to go forward. You just had the big state, big government, U.S. Solicitor General make a states' rights argument and had the Supreme Court defer to it.
Local issue, local courts, fight it out, boys.
It's exactly what we want to have happen.
Mm-hmm.
So that's why that one was worthy of bringing up, I thought. But they didn't listen to it, so we don't have to talk about it anymore unless you live in Hawaii.
All right.
Okay, let's do Javier Becerra versus Braidwood Management. It's a case that goes after the ACA, the Affordable Care Act, particularly their preventive services mandate. So Becerra is arguing that they created a task force called the U.S. Preventative Services Task Force, the USPSTF. Government loves our acronyms. And Becerra is arguing that it does not violate the Appointments Clause of the Constitution. They argue that Congress appropriately delegated the authority to the HHS to create this department and give them all this authority. And they said they justified it because of the quote-unquote public health benefits that highlights how the preventive services requirement has led to better health outcomes, lowering healthcare costs and supported public initiatives. All nonsense about lowering costs. They're also arguing that this ruling would have a limited impact. The respondents are asserting that the members of they should be considered principal officers under the Appointment Clause, and therefore they need Senate confirmation and presidential nomination. If they're going to be making these kind of rules, they need to go through the confirmation process. They're also arguing under the Religious Freedom Restoration Act that here's where it gets down to the requiring coverage of certain preventive services. We're talking like pre-exposure prophylaxis, HIV prevention, and others violate their religious beliefs by forcing them to facilitate or pay for behaviors they oppose, i.e. homosexual conduct or drug use. They're also relying on what's called the non-delegation doctrine, which we've talked about.
Well, and we have to remember the Affordable Care Act case. One of the things that was shot down was the mandate. Government can't dictate to you what what you have to buy or not buy, and I think that also plays a part in this.
Yeah, very much so. Lower courts partially upheld. The Fifth Circuit partially upheld the lower court that the structure of the U.S. PSTF was unconstitutional. They used the appointments clause. More importantly, what are the implications? If upheld, this could lead to the reevaluation of how preventative services are mandated under the ACA. There's that word, mandate. It could potentially affect coverage for millions without cost sharing or services like cancer screenings, vaccination, or HIV. A lot of people getting involved filing amicus briefs on this, and it's a big deal. It will drastically change the insurance costs. Depending on which direction you go, the insurance costs are going to go one way or another. Are you paying for someone else's quote-unquote preventative care?
Right.
Hopefully, this becomes such a hot-button issue that we actually get a repeal replace back on the ticket while we have Republican majorities in the House and Senate. We thought that was going to happen in 2017. It did not. Thank you, John McCain. Cast the deciding vote with his thumbs down at the last minute, even after arguing for 5 years against the Affordable Care Act. So that's why this is such a big deal.
And the Fifth Circuit said it did, if I remember properly, that it does violate the appointments clause, and so now it's on appeal. And the Supreme Court said, they took the appeal, and so the decision is pending at this point.
Yeah, and we probably won't get that till the spring, but you won't see any legislation on the ACA until this comes out because it does.
Right.
It's going to address a lot of things.
Mm-hmm.
I think the last case in this, we can do the 7-county infrastructure coalition versus Eagle County, argued on December 10th. This is a case that this centers on the extent of the environmental review required by the NEPA, the National Environmental Policy Act, for federal products. Basically,
now, real quick, where in the Constitution does it give the federal government the authority to make laws and have agencies regarding the environment?
That would be the 38th Amendment.
Right.
What? There's only 27? Basically, it's talking about overregulation. Right now, you try to do a big project, everybody's been in the construction industry knows this. Mm-hmm. You've got to get like 11 different agencies to sign off just to dig a ditch. There's got to be jurisdiction.
I was in construction for 20 years, and I mean, we were on job sites where don't go anywhere near this particular fence because it's there to protect such and such plant. I mean, it's just. But anyway, go ahead.
Well, you've got to, you weigh that. You've got to have some regulation because we've seen what what these corporations will do if you just don't have any rules at all.
Right.
Lake Erie will catch on fire. That kind of stuff. We've seen it. So you do have to have some environmental regulations, but the decision has to be a balance. How much overreach is there going to be? You've got these green NGOs. They're going to push and push and push because they want to shut down all industry. So we go back to worshiping Gaia. That's at the heart of that ridiculous religion. But you can
worship the creation, not the creator.
Yeah. You can be an environmentalist, wanting a clean environment, clean water, clean air.
Hey, I like to golf and go hunting. I want my world green and fresh, and also I'm a logger. I like my trees growing back, but not to the point where I'm going to say, for example, starve an entire southern section of a state of water and then let it burn up to a crisp. But you've got to find a balance.
Yeah, the balance is what they have to find. How much regulation? We need Goldilocks here, and that's probably where the Supreme Court's going to go, and that's where most of the oral arguments were coming from coming from the conservative groups. Obviously, the implications are profound. We've got some precedents. Recent goes back to Chevron deference.
Well, and then the question here goes that is this really something that should have stayed with the state? Let the state do the regulating when it comes to environmental impact, or is this something the federal government really has the authority to get involved in? It really doesn't. State law is supposed to be what is the deciding factor here when it comes to environmental review and environmental questions.
Well, that brings up a really interesting question, and that it's still being weighed. If two states share the same river, don't they have to agree on what the violations are? You can't pollute upstream and send it downstream. You're violating those pieces. And the same thing with air and other shared resources.
Disputes that cross state lines absolutely then becomes a federal issue. Not because it's cross state lines, but because it's a dispute that crosses state lines.
But you're saying, like, say, the Delta smelt, nobody would have any. That's California's business and California's only.
That is California's business.
All right. Well, Doug, that's a pretty good effort there.
By the way, no one has seen a Delta smelt in like 10 years.
I heard that too, and somebody posted on the internet something like a $10,000 reward for anybody who could produce a live Delta smelt. And somebody's got one in an aquarium they're going to go collect, but Well,
I don't know, man. I think anchovies have more meat on their bones than these Delta smelts, but
I've been ripping on the Delta smelt for a while, but
it's not even indigenous to California.
No, it's an Alaskan fish. And the Delta is the waterways near Sacramento. There's good water to be in there, but it's a nightmare.
So, hey, let's dump all of our rainwater into the ocean. Don't worry, we won't have a big fire. We won't need that water.
Different topic for a different show.
Yeah.
Doug, thanks for doing this preview of the Supreme Court decisions. There's a lot more coming on this stuff. We will, when the Supreme Court starts rendering their decisions, we will be talking about it. And
we'll be all over it, right?
Yep. We'll do what's called the SCOTUS scorecard, where we'll give each decision a letter grade, A through F. And from a constitutional standpoint, not from, like I said, there's legal eagles out there that'll make different arguments than we're making today. Today's all about original intent of the Constitution. Will they follow it? And that's what we'll be grading them on. Doug, where can everybody find you?
DouglasVGibbs.com. That's all you need to know. DouglasVGibbs.com. I do write pretty regularly of late, so hit the blog link or you can just go straight to the blog with politicalpistachio.com. Either way, I have new books on the way, DouglasVGibbs.com, and I am also a radio host on 3 radio stations in Southern California, but you don't have to live there to listen. You can go online, KMET1490am.com for my show on Saturday, 1 to 3 p.m. Pacific, or anywhere on any podcast platform for my show that airs on KCBQ and KPRZ in San Diego County. All you need to do is go to your favorite podcast platform, iHeartRadio being one of them, and you can do that with your TV if you have a Roku TV, and just put Mr. Constitution Hour by Douglas V. Gibbs.
Very good. If you're watching my channel, you know where to find me, War Space Hamster on Rumble. I've got a few other video channels out there. But see if you can find me on YouTube. I want to grow the following there. Spending a lot of time on True Social at War_Hamster, and my Twitter following is starting to grow. It is at War_Hamster1776. Think in the very near future you will see Doug and I doing a review of the Confederate Constitution with our good friend Ron Partaine's going to join us because
he's all excited about that.
Yeah, he is. I haven't had him on my channel in a while, so it'll be good.
But Ron and I, for those of you who follow what I do, every Tuesday at 3:30 in the afternoon Pacific time, we do a show that goes through the Constitution, and it's on Ron's channel, but you can find it at MrConstitution.com and put a hyphen between the MR for Mr. and the C for Constitution, so it's MR-Constitution.com, and learn the Constitution of those videos. But that's Ron, and
his channel is the Untold History channel. If you want to be live and participate in the chat, which I do from time to time, including last night, I was on there. I wish I could have come on live last night. I just had a lot of work to finish up. All right, let's give it a wrap. Doug, thank you once again for being here as always. Everybody, thanks for watching.
Always a pleasure.
See y'all soon. Cheers.